Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today I get to talk about two of my favorite subjects, ham radio and jurisdiction. It's actually part of a case, and that case involves two litigants, the Hytera Corporation and Motorola. Now this is a DMR radio. DMR stands for Digital Mobile Radio. It is a protocol that uses, among other things, the internet to transmit information, voice, and data across the entire globe. I can use this radio to talk directly to one of my subscribers on this channel, Bill, who is also a ham radio operator and who also has a DMR radio. And I can dial his number just like I would on a telephone and hit the right button, and we can have a DMR conversation, assuming his radio's on and he's able to talk, of course. So it's a marvelous little invention, and it involves a whole lot of electronics in there, as you might very well imagine. Now, when I talk into that, it goes out to something we call a hotspot that looks a lot like this. In fact, that is my hotspot. And the radio talks to that, and then that talks to the internet, and it runs around out there in electron land until it lands at the place where I'm asking it to talk, and then it goes through the gateway and talks to someone there. All of that happens in milliseconds. So again, pretty amazing when you get right down to it. But all of these things depend on electronics. Now, digital mobile radio was an outgrowth of research that was initially done by Motorola Corporation. And Motorola produced the first of these digital mobile radios. And this occurred many years ago, and they were the size of those really ridiculous looking cell phones there for a while, the big, long, tall cell phones. But they were functional, and a lot of people used them. They were used a lot in commercial radio. When someone had a commercial radio license, like in a warehouse, and you needed to be able to talk from one end to the other, and you wanted to be able to talk to shipping differently than you did product retrieval or the finance people or the billing people or something like that. Each of them had different what are called talk groups, and you could switch between talk groups, and you didn't have to bother the people in billing when you wanted to talk to somebody in finance. So it's really a well-designed system, and it used time division multiplexing. So it used a series of different patented devices in order to communicate in this way. Well, after the patents expired, a lot of different people got into the DMR space. And Anytone, that's who makes that radio, one of them. And I think they did a pretty good job with that radio, but so was Hytera. But somewhere along the line, somebody at the what my friend Bill calls the Batwing Corporation, Motorola, because their little logo sort of looks like bat wings, I guess. They got a little bit crosswise with the people at Hytera, and they filed a lawsuit. What's interesting about lawsuits is that we here in the United States seem to think that we are the only people who can file them. We do sort of recognize that over there in London and England, they occasionally come across with a lawsuit that is of interest. The Johnny Depp case sort of springs to mind when he sued the Sun there for defamation. But for the most part, we think of it sort of as an American institution, and I think our media has a large role in doing that, frankly. But that is the way the world sort of works. We tend to think we have the best courts and the best judges, and as a result, we tend to operate and think that way. Hytera, however, which was I believe a Chinese corporation, decided it wanted to enter into this market. And one of the things that a lot of Chinese companies do, certainly not all of them, but there has been a string of companies over the years who have simply essentially stolen all of the details and all of the technology for a particular product and then made a much cheaper version in a place where people work for pennies a day. And of course, when you produce a product that costs a lot less, you can sell it for a lot less. You can undercut people who have spent years building up a market. One of the things you may have seen if you watch very much YouTube are these little radios called Baofeng radios. And of course, Baofeng radios are very well known now. They're little VHF radios that a lot of ham operators use, but a lot of people use them for GMRS because many of them are unlocked. They're not supposed to use them for that, but a lot of people do. And as a result, this sort of infiltration of the ham market, among others, the communications market generally, by Chinese companies, has created a situation where Motorola felt like it was necessary, in this particular case, to bring a patent infringement lawsuit against Hytera. Now, this case was a case of stolen trade secrets. Motorola basically suggested that Hytera had stolen their trade secrets. Now, trade secrets are different from patented ideas. A patent is publicly disclosed. The information is out there for anybody to look at. They just can't use that patent without paying a licensing fee and getting the permission of the person who developed the patent. But the patent had already expired, but that doesn't mean that the trade secrets had expired. The trade secrets are protected, forever. Otherwise, people would be able to duplicate the formula for Coca-Cola. The formula for Coca-Cola is a trade secret, as is the formula for Pepsi, and I'm sure the formula for Coors beer. At any rate, that's what's at the heart of this, the fact that trade secrets have been stolen. Essentially, the district court in the District of Illinois, and Motorola is an Illinois corporation, they found that the Hytera equipment and the Hytera engineering essentially duplicated the patent of Motorola without paying the appropriate licensing fees and all of that. And I think that Hytera probably had some idea that this was the way things were going to go, because they went to the People's Court in China, and apparently they don't have a judge that appears on TV in the People's Court, but they went to the People's Court and they filed a declaratory judgment action. Now, one of the things we've talked about before on here is that declaratory judgment actions state what somebody's rights are with respect to a document or contract or a statute or even a constitutional provision. Essentially, you go to the court and you say, these are the facts, and we want a declaration that, we're in good stead here. If you run off to a foreign court and ask that court to give you a declaration, you then set up the situation where you essentially undercut the remedy of the court in Illinois. Well, the court in Illinois was not amused by this, and let's take a look at the order. So this is in the United States District Court for the Northern District of Illinois in the Eastern Division, and it's Motorola Solutions Incorporated and Motorola Solutions Malaysia versus Hytera Communications Corporation Limited and Hytera America Incorporated and Hytera Communications America West Incorporated. Those are the defendants, and our judge over here is Judge Martha M. Packold, and she is a relatively new judge in the Illinois courts. So here's what they say. An injunction and additional sanctions, the contempt sanctions, are imposed on defendant Hytera Corporation in order to coerce Hytera's compliance with the anti-suit injunction orders, docket numbers 1504 and 1508, that this court has entered regarding litigation Hytera filed in the Shenzhen Intermediate People's Court in China in June 2022, seeking a declaratory judgment that the H-Series products do not infringe Motorola's trade secrets and copyrights, the China action. Now, I had previously said patents, but I should have said secrets, trade secrets and copyrights. There's a difference between a trade secret and a copyright, and also a patent. A patent is publicly disclosed. This is how we build, the ark. A trade secret is the secret sauce that goes in between the boards on the ark, and that's not part of the patent. So the trade secret is different, and you can steal a person's trade secrets and use them. And if you do that, you can be held liable. And that's essentially the issue in this particular case. On March 25th, 2024, this court directed Hytera to refrain from further pursuing or enforcing its China action, and on March 29th ordered Hytera to withdraw from the action, including withdrawing any productions in that case. The court finds that Hytera is in violation of these orders, including, as discussed during the April 2nd, 2024 telephonic status conference. Unless otherwise noted, these contempt sanctions are effective until Hytera is in full compliance with the court's order or until this court orders that it be terminated. It is on the 2nd day of April 2024 hereby ordered as follows. Until Hytera is in full compliance with the court's anti-suit injunction orders, 1504, 1508, Hytera and all of its officers, agents, servants, employees, affiliates, subsidiaries, distributors, and resellers of any type, and all those persons in active concert or participation with any of them, who receive actual notice of the order by personal service or otherwise, are temporarily enjoined from performing any of the following actions. 1. Offering to sell, selling, importing, exporting, or otherwise distributing anywhere in the world any two-way radio products. And then they drop a footnote and they say, two-way radio products refers to any products containing two-way radio technology, including portables, mobiles, base stations, and repeaters, and includes but is not limited to DMR products, including the I-Series, H-Series, and any other DMR products, Tetra products, cellular products, for example, LTE or other push-to-talk over cellular products, and analog products. So that's pretty much the catalog of Hytera equipment. Moving along. In order to encourage compliance with this injunction, Hytera shall notify in writing all of its agents, affiliates, subsidiaries, distributors, and resellers of any type, customers and prospective customers of two-way radio products anywhere in the world, of the entry of this injunction, as well as the requirement that those entities and or individuals comply with this injunction by providing them with a complete copy of this order, including the attached form notice, Exhibit A, using the last means of communication for that entity or individual. And then it says you have 3 days to do that. Also, no later than 3 days of after the entry of this injunction, Hytera shall publicize the entry of this injunction by placing the following notice prominently on the home page of its website and any page on which it markets any of its two-way radio products, including all pages for any region or language for which Hytera maintains a website in the region. Notice to public. By order of the United States Court, until further notice, Hytera is prohibited from selling any products containing two-way radio technology anywhere in the world, with a link to the copy of this order. And then, within 5 calendar days of the entry of this injunction, Hytera shall file with the court evidence that it has complied with the above notice requirements, including a list of all of those whom it has provided notice, including agents, affiliates, subsidiaries, distributors, resellers, and any type, customers and prospective customers that have notified, copies of its correspondence with those entities, and a copy of the press release it's issued, and confirmation by providing screenshots that it has placed the required notification on all of its requisite website pages. And then, just to make sure that Hytera gets the point, Hytera is ordered to pay a daily fine to the court of $1 million until they're in full compliance with the anti-suit injunctions. One further shot across the bow, Hytera is hereby authorized that it may not enforce or otherwise rely on any orders or judgments issued by the Shenzhen court in the China action until the contempt proceedings in this case regarding the H-Series have concluded, and this court can consider and make further orders necessary to redress any prejudice to Motorola from any such orders in the China action. We recently spoke about splits in the circuits, where an issue comes up of a legal nature and the Seventh Circuit decides it one way and the Third Circuit decides it a different way, and then it has to go up to the Supreme Court to be resolved if the Supreme Court is willing to resolve it. Well, one of the issues that is currently not been decided by the United States Supreme Court is this issue of when it is appropriate to enjoin litigation in a foreign forum. The Seventh Circuit, where this Illinois court sits, has a very lax rule, and basically it says you can do this if it's necessary to effectuate your judgments. And other circuits, particularly the Sixth Circuit, do not hold that way. In this case, Gauchan Company versus Bankers Trust Corporation, the Sixth Circuit said parallel proceedings should be allowed to proceed simultaneously. U.S. courts should not enjoin the foreign suit. So there is very clearly a split in the circuits here. Now, here's the reason that's important. How does a federal court have the ability to police what Hytera Corporation does in Japan? How does it prevent them from selling these in Malaysia? How does it stop Hytera from selling its equipment in Australia, other than through these punitive sanctions? And of course, Hytera could very easily avoid those punitive sanctions simply by closing shop here and continuing to operate out of China and selling worldwide and essentially thumbing its nose at the Seventh Circuit and at this particular court. Now, I doubt that's going to happen, but because I'm sure that Hytera wants entry into the United States market. It's probably one of the biggest markets available for communications. But this presents an interesting jurisdictional question because the issue of whether or not the court has the jurisdiction to do this is up in the air. It hasn't been definitively decided really by the Seventh Circuit or any of the other circuits. It's simply been on a case-by-case basis. There is no holding that essentially says, by the Supreme Court, that says you can do this. So it could very well be that all of these punitive sanctions that would be paid into the court, all of that, may wind up having to be refunded, and there may in fact be a real issue with Hytera having been damaged by this injunction and by the bad publicity generated by the injunction. So this is something that if I were advising Hytera, I would urge them to appeal first to the Seventh Circuit, and when they lose there, as they most likely would, I would take it up to the Supreme Court and ask that question. How does a court in the United States have the authority to prevent someone else from justifying, or from a foreign court from acting as a foreign court? It's essentially saying our courts are better than yours, and while I believe that to be the case, I don't think the people in China believe that. So that's the issue. And it's an interesting case. I hope you have found this thought-provoking. If you have any questions, leave them in the comments down below. My thanks to Bill, one of my subscribers, who brought this to my attention. And if you have the opportunity today to do something kind, please take advantage of it and do something nice for somebody. Make their day. And then come on back and catch me down here at the beach again next time. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.